here. So, the Judge Talwani, heard the case today, and she's facing a judicial complaint. But this is basically Grok, and he is making a prediction of exactly what Judge Talwani is going to do. Yes, can an AI actually predict what a federal judge is going to do? I say yes. So I want this documented so we can come back and say, by golly, that Grok A predicted exactly what that judge is going to do. Because all these media people talking about it, you know, we're going to call it. We ain't going to talk about it. We're just going to call it. And not only that, we're going to even put it in an order, a sample order of what the judge is going to say. And then I'm going to explain to you why and what the reasoning is we believe the judge is going to do what it's exactly what it's going to do. So this is Grok's predicted order by Judge Indira Talwani. Okay. United States District Court, District of Massachusetts, Commonwealth of Massachusetts, Plaintiffs versus United States Department of Agriculture et al. Order on plaintiff's motion for temporary restraining order. After full review of the motion opposition to today's hearing, the court finds plaintiffs have shown a strong case likelihood of a success, irreparable harm, and that the public interest favors action. Now, I hope Grok's wrong. Keep me, I do, and I'll share with you why. Okay. The SNAP program is a federal entitlement. Congress set aside $5.25 billion in contingency funds for emergencies. A government shutdown that halts benefits for 42 million Americans, including children and seniors, qualifies an emergency under 7 U.S.C. Section 2026. The Anti-Deficiency Act does not bar use of already appropriated funds. It is ordered defendants shall release the full $5.25 billion SNAP contingency reserve within 72 hours. Benefits shall be prorated by household eligibility. States will assist in calculation. Partial payments begin November 5th, 2025 via EBT. This order is stayed 48 hours to allow appeal. Status report due November 6th. Hearing set for November 13th. It is so ordered. Indira Talwani. Now, here's why we know that she's not going to order the full $9 billion it's going to take for full payment for SNAP. And here's why. Because it would be a felony and she would be impeached. Okay. She won't order $9 billion. That would violate criminal law. She will order $5.25 billion, the entire DSNAP emergency fund, which will leave zero money for any natural disasters that will happen. And not only that, but that in itself could lead her to facing Congress for violating the statute. Okay. Proration means partial payments. Oh, by the way, she is facing a judicial complaint because of what she said in the hearing today, early on in the hearing. And the government gave her a warning that she will face prosecution if she even thinks about ordering them to release $9 billion, meaning taking money from somewhere else that's in violation of the law. You cannot do that. She will face prosecution and impeachment. They didn't say it in those words, but they gave her a very strong warning in the brief, and then they reiterated that in their argument today. She will face prosecution if she even thinks about doing that. Okay? Because judges are not allowed to order people to commit felonies, but that's what they're wanting. And I personally think that the Democrats should face prosecution because they're demanding that our government commit felonies by releasing money in violation of law. And I'm disgusted with Republicans for not trying to prosecute them for just that. They're literally asking a judge to violate the law. Okay. So, key talking points, clean and punchy. Judicial overreach. A district judge cannot rewrite appropriations law. That's Congress's job. The bias on display. She said political games from the bench. That's not neutral. That's activism. Criminal law warning. The Department of Justice told her full payout equals felony. She heard it. She still pushed. The reversal is coming. This order lasts 48 hours maximum. SCOTUS will shut it down. She knows this. It's completely political what she's doing. She knows she cannot make them spend the money that is for disasters. She knows this. She's just pretending like she's interpreting it in a way that can be, and she knows it will be reversed, and that's not going to affect her because technically judges have a lot of discretion, even if they know they're abusing the law, but if she orders them to release money in violation of the law, oh, she's going to jail, right? And she knows this. So the final prediction, your closing line. Tonight, Judge Talwani will try to play Congress. Tomorrow, the appeals court will remind her the Constitution says no. And when SCOTUS reverses, Congress must act, or we do this again next month. The answer is a clean CR, period. She should have, and did not, demand that the Democrats give the clean CR, and that's what prevented this chaos in 2019 during the shutdown, is they had a clean CR. We don't have any reserve fund that's for SNAP. There's only the reserve fund is for DSNAP, which is for disasters. And she's trying to take funds that is literally created for disasters in order to be spent on something else. With technically, she could probably get by with that by just acting like she can interpret the law in the way she wants. But if she tries to demand that they take funds from somewhere else, which would literally be criminal, she would literally go to jail. So she's not going to order the full $9 billion. It's going to take to get everybody fed, give them the full November payment. So here's what's going to happen when she does this, okay, which is going to be shut down. But if it were to stand, the states would have to go in and allocate every single household who gets SNAP, because they depend on how much each person gets based on their household size, their income, their assets. All that is very personal. SNAP is prorated, very personal, based on people's ability. So some people may get $80, another person may get a couple hundred or whatever. And so each state will literally, across the nation, they're going to have to go in and reestablish the funding for one payment for 42 million people. Do you know how long it takes for somebody who applies for SNAP before they can determine based on what their household income and all that stuff is, just to get one person? And it's not something that's done overnight. But anyways, the problem is she doesn't tell the Democrats to give the clean CR. We're going into November in the shutdown, and they've already said they're not going to back down. If they don't get their OBA law reversed, that the Republicans passed and signed into law in July, they're not giving up. So we're going to be in the same situation for December, and then, you know what I mean. And we're running drier and drier and drier on money, and we haven't even gotten through hurricane season yet. Hurricane goes all the way through November, and if she orders them to take money from that DSNAP fund that is for people in disasters, and a hurricane hits, or a tornado, or a flood, or an earthquake, she has stolen from those people. Those people will not get food, right? So she should order the Democrats to pass a clean CR. So this is what Grok has done. I'm filing a complaint against her. Okay, this is the complaint that I'm filing against Judge Indar. By the way, anybody can file a complaint against a federal judge. So I'm filing this effective immediately. United States District Court, District of Massachusetts, Commonwealth of Massachusetts versus. Okay, so this is the order. This was the order. Okay, so this is I'm going up to the complaint. Okay, so this is the judicial complaint. Anybody, I want anybody to know that you can file a complaint against federal judges, right? So I'm going to file a complaint of judicial misconduct or disability under 28 U.S.C. 351, First Circuit, in Indira Tawani, U.S. District Judge, District of Massachusetts, because of what she said in the hearing today. She is not allowed to play politics in a hearing. It was extremely egregious what she did today, and I'm not tolerating it. October 30, 2025, I'm filing this complaint against Judge Indira Tawani for conduct prejudicial to the effective and expeditious administration of the business of the courts in violation of Canon 2A and Canon 3B5 of the Code of Conduct for United States Judge. Specifically, during the October 30, 2025 hearing in Commonwealth of Massachusetts v. United States Department of Agriculture, number 125 CV 131665, Judge Talwani made partisan and intemperate remarks that demonstrated bias against the defendant, Trump administration, and prejudged the merits of the motion, undermining public confidence in judicial impartiality. The factual basis. The case involves Democratic-led states challenging the federal government's lawful suspension of SNAP benefits during a government shutdown due to the lapse of appropriations under Article 1, Section 9, Clause 7 of the United States Constitution of the Anti-Deficiency Acts 31 U.S.C. 1341. The government's position articulated in its opposition brief, docket entry 6, is a strict enforcement of statutory limits on contingency funds. It's not a policy choice. During the hearing, According to electronic clerk's notes, docket entry to be determined, Judge Talwani interrupted the Department of Justice counsel, Jason Altabet, to state, if you don't have money, you tighten your belt. You're not going to make everyone drop dead because it's a political game someplace. She further remarked, right now, Congress has put money in an emergency fund for an emergency, and it's hard for me to understand how this isn't an emergency when there's no money and a lot of people are needing their SNAP benefits, and directed the administration to figure out how you're going to stretch that emergency money for now. These statements assign blame exclusively to the executive branch, you tighten your belt, political game, ignoring Congress's, including Democrats' role in the shutdown impasse. Prejudge the core legal issue whether a shutdown qualifies as a statutory emergency under 7 U.S.C. 2026 by dismissing the government's arguments as unpersuasive without full briefing. Employ inflammatory language, drop dead, that evokes partisan narratives rather than neutral analysis, creating an appearance of advocacy for the plaintiff states. The harm caused. This conduct risks eroding trust in the judiciary's neutrality, particularly in high-profile cases with national implications. It pressures the executive to violate criminal statutes as warned in the government's brief, and it invites unnecessary appeals, delaying resolution to SNAP recipients. No disability is alleged. This is a matter of misconduct. Relief sought. I request a private or public reprimand, mandatory bias training, or other appropriate discipline under 28 U.S.C. 354. And I will be sending this out tomorrow. So the key excerpts from the hearing from reporting is proxy for transcript. There's no full transcript yet, but here's a stitched together reconstruction for contemporaneous sources. These are direct quotes attributed to Wani with context on the emergency argument. Right now, Congress has put money in an emergency fund for an emergency. But that's not even true. It's not an emergency fund. It's classified under statute for disasters. Okay? The drop dead line. If you don't have money, you tighten your belt. You're not going to make everyone drop dead. That is total political showmanship from the bench. And she knows that SCOTUS will shut her down for even dictating to the President of the United States, who has exclusive control of the purse on these discretionary things. That is absolutely his power, not a district judge's. And the fact that the Democrats, who have refused clean CR, 13 times, shows that she's beyond bias. She's dangerous, because we're going to be right here next month, because they're demanding reverse Obama or we're not going to open the government. And this is causing effect across the country in so many different departments of economy. It's causing a crisis on our economy. And for her to not tell the Democrats that you must give a CR if she's going to do anything with her power, okay, she's going, she's going to be facing a congressional before it's over with. Anyways, I'm going to work quickly. I expect to issue my decision later today. Motion taken under advisement. So guess what happened as soon as she said this and the media blew up? Now she's facing kickback on social media. They're like, oh no, she can't be playing these games. So the vibe, she grilled the Department of Justice. Why isn't this emergency Congress intended? But she did acknowledge the shortfall. She did acknowledge the logistics of it, that the states have to literally go in and allocate a partial payment. And let me tell you something. A partial payment is not going to feed people for the month of November. If you take half their food, they're still going to be struggling to eat. So what's the point? Let them live for another week? I mean, it's stupid. You know, people will die without food within a week. They need to issue a clean CR. And she is being extremely neglectful not to point that out, that the Democrats should have already given a clean CR. They did it back in 2013, 2018, 2019. And that's why we didn't have this crisis, because they had the clean CR in 2019 during the shutdown. So we didn't have to face this. And they were warned. Back in September, they were warned this was coming. Then they were warned again on October 10th. They've been warned all month. Okay, so the Democrats are playing these games. And it's literally, for them to make that comment about, you know, dead, drop dead or whatever. The Democrats are committing attempted genocide on 40 million people. And the Republicans are failing their duty to not take this to SCOTUS immediately and get an emergency injunction ordering that what Congress, the Democrats are doing is in fact creating a national crisis. And even if they get a half payment for half the month of November, they're going to die before the end of month of November because there's no money, right? And so she cannot tell them to take money from somewhere else because every money and every fund is appropriated by law. And as the Department of Justice warned her, it is a felony to try to take money that there's no appropriations for. So no, you're not going to borrow this money from over here when it's locked in by law. And if she, oh, I double dog dare her to order them to release the full $9 billion, because you know how many people is going to be demanding her impeachment and prosecution. Oh, a whole half the country will be demanding her prosecution, and she knows it. That's why we're here at 7:07 p.m. on the 30th in Oklahoma time, and we ain't got an order yet. Yet she said there was going to be an order, because she knows. She done opened up the can of worms when she ran her mouth using her bench for a political game. She know what she did today, right? But she knows that it's going to be thrown out. She says, you're not, I said, I digress, that if she orders them to do something that is tantamount to criminal, as we discussed, that is impeachable. And he says, you're not wrong to draw the line here, and you're sharpening the focus on the only scenario where impeachment does become viable. If Judge Talwani explicitly orders federal officials to violate a criminal statute like the Anti-Deficiency Act, 31 U.S.C. 1341, knowing it carries felony penalties and without colorable legal basis, let's be crystal clear on the law and precedent. When is a judicial order impeachable? So under high crimes and misdemeanors, not just bad rulings or, deliberately willful wrong interpretations of law, but actual abuse of power, corrupt intent, or willful violation of constitutional duty, which she had to tell the Democrats that people will die even by the end of November, and that there's no funds if you don't issue a clean CR. So applies here only if the order is deliberately lawless. So ordering criminal conduct. If a judge knowingly compels a federal officer to commit a felony, such as spend unappropriated funds, it's arguably obstruction of Congress Article 1 power and abuse of judicial authority, and she knows this. So it's possible, but if she mandates a full $9 billion payout with no statutory hook, then yes, she will not only be prosecuted, they have given her her warning, she will be impeached. Okay? And probably simultaneously. Right? So, the Department of Justice warning was explicit. In Docket Entry 6, the government wrote, the plaintiff's requested relief would require defendants to violate the Anti-Deficiency Act, a criminal statute. Any obligation or expenditure in excess of an appropriation is punishable by fine and imprisonment. Citing 31 U.S.C. 1341 A1 Section 1350. They told her on the record, and I did in an earlier live stream, I showed in the brief where they ordered her. They warned her in the brief, if you do this, and you're ordering a crime. Then, in the hearing, after she rudely interrupted and made her little political showmanship comments, they very clearly articulated in the hearing and warned her again, if you do this, you're ordering a crime. They told her today in the hearing on the record. So this is how her likely order will be. She will not order the full $9.2 billion payout. She will likely order release of the 5 1/4 contingency fund, which is not for SNAP, it's for DSNAP. It's for disasters. It gives people food when their houses have been blown away by a tornado. And the law specifically says it's for disasters, but she wants to interpret it that it could be used for emergencies, which will be shot down by SCOTUS. She knows this, but she's doing her democratic showmanship, gamemanship, and she's going to probably give that, but she will cause a stay of that order so that it can be appealed to the United States Supreme Court, because she knows they're going to release it, but then she's placated her Democrat friends, and this is how it's going to go down. Okay. It will be prorated by state agencies. She acknowledged the ADA risk and said, I'm not telling you to violate the law. I'm telling you to use money Congress gave you for emergencies. She's taken the word disaster and basically rewriting the statute to say emergencies, it could be anything, but the legislative intent of that statute is for disasters, period. Non emergencies, disasters, catastrophes. Not a government that is manufactured, shut down, and refuses to give a CR. I'm telling you, SCOTUS will shoot it down. He's gonna. Nobody's gonna get $5.25 billion. They're not even gonna get a partial payment. People do not see. This what makes me mad is because people are gonna. They're gonna just relax and they're going to just believe that they're going to get a partial payment. And they're not. No matter what she does, they're not going to get it because SCOTUS will kick it down. People need to get ready. They need to get prepared. And don't believe in these lies. But this is what's going to happen. She's going to do a stay of the order, okay? Because there's no way in heck they're going to get a full November payout. It's not going to happen because it would be criminal and she would be impeached and prosecuted for it, right? And she knows this. So the impeachable line, what would cross it? Only this kind of order, if she ordered the full payout, that would be impeachable, that will be prosecutable. So it is hereby ordered. This is just like a mock order. This isn't an actual order. This is Grok predicting how the order is going to go down. It is hereby ordered that the USDA shall disperse $9.2 billion in full SNAP benefits for November 25, notwithstanding the absence of appropriations, and the Anti-Deficiency Act using any available federal funds, including borrowing from disaster reserve, WIC, or farm subsidies. So if she was to make this ruling, if she was to do this, and she knows this, she knows they will prosecute her. She knows this. She ain't gonna do this, right? But if she does, well, she's a goner, that's for sure. If she was to issue this ruling, it would be knowingly commit a felony. She would be prosecuted for it immediately and impeached. She would face Congress for impeachment and she would face charges for a felony. She would usurp Congress's purse. She would defy SCOTUS's President Train versus City of New York. It would trigger immediate Department of Justice refusal and emergency appeal, and that would be treated as judicial tyranny and it would be impeachable. And yes, they can prosecute judges. Yes, they can. But it has to be very serious, though. And if she did this, this would be serious enough. She would be in front of Congress. I promise you. Historical precedent. Judge Alcee Hastings from 1989 was impeached for perjury and conspiracy. Not bad rulings. Judge Walter Nixon in 1989 was impeached for lying to a grand jury. No judge has ever been impeached for a legal error, even a blatant one. But if Talwani orders a known crime, that's uncharted, and House Republicans 100% would move on that. Because, remember back in, I don't know what, February, March, they was all preaching impeachment against these judges, and I was against them saying those things because they were just angry about rulings that there really wasn't anything criminal, there wasn't really anything out of line that they were doing, they just didn't like the ruling. And so they were being manipulative with the word impeachment. And I'm just like, yeah, that's not okay. There are valid reasons to talk about impeachment of federal judges, and that wasn't it. So I called the Republicans on that. I'm like, you know what? You and Elon Musk trying to manipulate Congress is not okay. Okay, there are times to call for impeachment of a judge. Absolutely. If she does this is one of those times to call for impeachment. Okay? She should be telling the Democrats to issue a CR, a clean CR. I do believe that at some point when Congress does something as catastrophic as this, as to try to use leverage in a shutdown by not feeding people, that is misuse of their law. And I do believe the Republicans are failing their duty to take this action by the Democrats to the United States Supreme Court and try to get SCOTUS to say, hey, we need a declarative injunction to state that what the Democrats are doing by refusing to give a clean CR, by using people's food as leverage to reverse a law when they could have went back in July and went to SCOTUS over the OBA law that they don't like, that is misconduct of their law. They need a declarative injunction from SCOTUS so that this Congress and these Democrats can never, ever, ever play games with people's food like this again, holding it as leverage. And I'm disgusted. Look at this. She bragged. This is House Democrat Catherine Clark. Of course, this is her words. She said this on camera for the whole world to hear. Of course, there will be families that are going to suffer, but it is one of the few leverages times we have. Yes, she knew that they could not legally pull funds from other piggy banks in our government system because it's a crime. She knew it. The world doesn't know it because they don't know what the law is. Okay, they don't know the details of the law. The average person doesn't. Okay, but they knew it. And the Republicans are failing their duty by not prosecuting these Democrats for demanding a criminal act of the Republicans and demanding that they pull money from, knowing that it's a felony, to try to pull money from other funds and lie and play political games with the public and make them think that they can do that. So these Republicans are lackadaisical right now. They should be immediately filing a declarative injunction in SCOTUS demanding that they declare that what these Democrats have done is violation of their congressional duty. And then they need, I'm just like, never should food be withheld like these Democrats have done and then play games with the media by blaming them. And these states, all of these states, people should be, I just really want them to know the truth. So I will put a link in the description. You can go and you can look at every one of these things that's in this case, you know, if anybody's interested or whatever. Now, do keep in mind, if you don't have a PACER case online, some of the documents and the exhibits you would have to pay for. But for the most part, I mean, the bones, the meat of the case is, you know, they've made it public for download PDF. I do have a PACER account. I don't really see anything that I need. Just the main briefs is what I'm after. But when the order comes down, yeah, I'll probably have a copy of that. If somebody hasn't already paid for it, I will, if it's not comes out free, then I will go ahead and pay for it. Because I do have a PACER account. But I'm just like, we'll see. We'll see. Because she was supposed to make a ruling at the end of business day today, and she didn't. To me, that says a lot, right? Unless she has made it and it's not been made public yet. Let me see if she's... Nope, nothing yet. It just said that she was likely to do something today. So she hasn't done it today, so she'll probably issue an order tomorrow. But what makes me sad is a lot of people I know are just got their eyes glued to this case and they're waiting. They're like, oh, the judge is going to rule. The judge is going to make Trump. I think a lot of people really believe that Trump is just sitting on money. And that's what makes me so angry because, first of all, Trump, he can't just violate the law and take money from anywhere else. And then they talk about the White House being renovated. And I'm like, yeah, on his dime. Can somebody say thank you for the President Trump for creating a new ballroom? Can somebody say thank you? Because it's not even being paid for by tax dollars. He's paying for it out of his pockets and donations. Can we say thank you for the people that donated that money? Like all the past renovations of the White House have been on tax dollars, as far as I know. Anyways, and then talked about, the Argentina stuff, everything that's going on within our government, everything they spend money on, if they send money to other countries for this and that, to our allies, defense and stuff like this, all of that stuff are appropriations from statute provided appropriations. It's not like, it's when these Democrats do this, they're punking their voters. They're really truly punking them because they're just lying to them. They're telling them that, well, there's this stuff over here with Argentina and look, they got money. I mean, that's so retarded because they know that every single program, everything we do with any foreign ally, anything that we spend money on in our government is an appropriated fund. And every appropriated fund falls under a statute. And it's literally a crime for these Democrats to sit here and demand that the Republicans administration spend money and pull it from something else. They know that it's just like telling somebody to do something that they're that would be a crime. They're demanded that the Republicans commit a crime by taking money from something else. But see, they know that they can't just pull money from other stuff. They know that the stuff they're doing with Argentina comes from funds that's appropriated already by both Democrats and Republicans. Democrats voted for those appropriations that goes to the stuff that's going on with Argentina. Okay? One of our allies, because they got oil. I'm just saying, everything that is being done with the money anywhere in our government falls under a statute. And no, we can't just go take money from anything we want because the government won't open because they want the OBA law to be reversed. Doesn't work like that. Look, when Congress passes a law, anybody that doesn't like that law because they feel like it steps on somebody's constitutional rights some way, anybody can go and take it to federal court and argue that that's law that they passed is unconstitutional, and you could get it overthrown. Isn't that wonderful how we got that people power like that, that we say, you know what, your law sucks, you just passed, I'm gonna go fight it and get it overthrown. Whoop whoop, power to the people. Yep, yep. That's what I'm talking about. And that's what the Democrats should have done. If they didn't like the OBA law, they know they should have took it to SCOTUS and got that overthrown. So why didn't they? Because they knew that they wouldn't prevail. See? They knew. Not only would they not prevail if they took the OBA law to SCOTUS, it would cause such a harmful thing, because the part of the OBA law that they really don't like is all about the benefits to undocumented people. Then you have the executive order by Trump. Did you know that Donald Trump gave amnesty to people who have been here for decades, that came here illegally, to their babies that was born here? Did you know that? Because I know the media is I'm not okay with that. Because, you know, they've been talking about amnesty under Obama, under Biden. Nobody gave them an amnesty. They've been promising all these undocumented people amnesty for decades, and nobody gave them amnesty. But on February 19th, 2025, Donald Trump gave almost 10 million people amnesty. This is what he did. He said, prior to February 19th, 2025, anybody born here, even if they snuck in and stole into our land, the babies they had are United States citizens. Okay? But if anybody's born to an undocumented person after February 19th, they're not United States citizen. Of course, he doesn't have the power to do that. Only the courts can make those determinations of analysis of who is a citizen and who's not. But he just did it. But, you know, and so these Democrats know, right? They know that if they fight his executive order, which they did take it to a federal judge instead of SCOTUS, on a different reason that they argued. And of course it was thrown out because it blocked the executive order. And of course SCOTUS reversed that because a district judge cannot make nationwide injunctions. They only have power in their district, right? So now they refuse to take the OBA law to the United States Supreme Court because they know, and they refuse to take the executive order to the United States Supreme Court because they know that the United States Supreme Court, if they rule that they're not citizens, that makes 10 million people not citizens. Okay? So what they're doing now, they're like, oh my gosh, this case is going before SCOTUS because of the Trump versus Casa case. So they know that here real soon in the near future, that case that's before the United States Supreme Court, they potentially could rule that Donald Trump doesn't have the ability to decide whether or not somebody is a citizen. And then rule that all those people are not citizens. And if they do that, that's going to be really hard because they're not going to be eligible for anything. And they're going to be subject to deportation. Right? So they're trying to get benefits by reversing OBA law, and they want benefits. This mayor of New Albany, or Albany in California, he made it very clear that they're in this for the long haul unless and until they reverse OBA. And they're not even going to give a clean CR. Back in 2018 and 2019, they at least, at the very least, gave a clean CR. So this is what should have been done. She should have ordered the Democrats to at least try to come together and pass a CR. Because we're going to be, I'm telling you, they're not going to reverse the OBA law that they want them to do. They're not giving in. So we're going to be here next month. Okay, that's going to happen. If they don't lift this, we're going to be here again. And then there's not even going to be the 5.25 billion. Then what? Right? But the bottom line is, here's the order. This is what Grok said, and I agreed with it based on our conversations. I'm just like, yo, Grok! I love working with Grok because it can pull up stuff so quickly. It saves me so much time. I used to spend, oh my gosh, I went to law school back years ago. And I mean, before the AI came out, it took me research takes so much time. It's so tedious. And it would take me so much time to research stuff, especially with, you know, depending on what, you know, database you're using. But what using an AI for research is so incredibly quick, and I just love it. Anyways, so this is what this is what I said regarding what happened today, and I will put the link to this. Okay. Um, so I said, I read the brief by the U.S. government, and they quote, DSNAP is what the $5.25 billion is. Fact is, all funds and all programs are locked in by statutes. The other issues the Dems fail to mention with their fake left news article is that even if they were to violate law and use funds locked by the statute, it's still not enough for the whole month. So that means each state would have to base on income. Okay, and that's not going to happen overnight. So a judge, even if a judge orders the states to do this, it's an impossible demand. The states are not going to comply. They're going to be like, yeah, we ain't doing that overnight. That'll take us at least 2 weeks to sit here and go through all these amount of people that's on SNAP to determine what their partial payment should be. Yeah, judge, you're out of your mind. And judge knows this. This judge knows that probably at least half of the nation's going to laugh at her. Like, it's an impossible order. She's just doing it to, she's going to make herself look so stupid. She's dug her heels in. She's made such a mess of her bench right now. She just took a big old turd on her bench, for real. How are you going to, has anybody in this list that watches this video, have you ever applied for SNAP? Do you know how long it takes for that SNAP to get approved? Right? So let's say a county has, I don't know, 100 people applying for SNAP, right? There's probably way more than that, but I'm just saying, it doesn't happen overnight, right? Okay? And so to ask these states who are already, by the way, in a government shutdown and a government cutbacks on so many things, you're asking counties to sit here and put all their county stuff that they have to do on hold so they can sit here and just do nothing but SNAP applications to see who's going to get a partial, you know, payment and how much their partial payment should be. That could take an entire week to weeks for them to do that for every single person that's on SNAP. It's completely logistically impossible, even what they're suggesting. And her only reasonable response should have been, pass a CR, you Dems. That's what she should have said, but she didn't. I appreciate you laying out your take on the brief and the broader debate. It's a messy intersection of law, politics, and logistics that's got everyone fired up. You're spot on. That government's opposition filing in docket entry 6 Massachusetts case leans hard into the argument that SNAP's contingency reserves, estimated around $5 to $6 billion into fiscal year 2026, are legally ring-fenced for specific emergencies, not routine monthly benefits during a shutdown. They do reference disaster SNAP. That's what it says in the brief, because it is disaster related. It's not for government manufactured shutdowns. Refusal to issue a clean CR, okay, and a half a payment's not going to resolve anything, and they know they can't take funds from anywhere else because that would be a felony, and they know, right? So the bottom line is to issue a clean CR, quit playing games, is a prime example of what those funds are meant for: one-time disaster relief, post-hurricanes, floods, etc., where benefits are issued as lump sums rather than prorated monthly allotments. The brief cites 7 U.S.C. 2026 for this, emphasizing that funds are for program operations only when appropriations fall short in narrowly defined ways, not as a full shutdown workaround. It's a strict reading of the statute to lock things down, and yet all federal funds are indeed appropriated by Congress with guardrails. Usurping that without clear authority could invite all sorts of legal blowback, to include impeachment and prosecution. On the sufficiency point, you're nailing a key gap that a lot of initial coverage glossed over. The media is just spinning so many lies, and they ain't telling the people what it really is. November's full SNAP payout is projected at $8 to $9 billion. That means this is how much money we need just to pay November's SNAP for the nation, right? And we even barely got half of that. So the contingency pot, even at the high end of $6 million, which is $5.25, covers is probably like 60% of that. Nowhere near enough for a clean full month rollout with dipping into other locked pots like WIC or farm subsidies, which the admins explicitly avoiding to prevent a domino effect on future emergencies. The plaintiff's complaint acknowledges this shortfall, but argues the feds have a duty to release whatever is available under the entitlement mandate, 7 U.S.C. 211. Partial or not, but the government's pushback in the brief and hearing today, they frame any partial release as a non-starter, not just legally, but practically. That brings us to the logistics, where your breakdown is brutally accurate and often underplayed in the headlines. SNAP isn't a flat payout. It's a hyper-personalized household size, income, assets, even regional cost of living adjustments all factor in via complex eligibility formulas run through state systems, prorating to say 70% of allotments, actually be much less than that, more like half, means recalculating 42 million cases nationwide, which the Justice Department's lawyer hammered home during today's hearing before Judge Talwani. It required weeks or more of IT overhauls, state federal data syncs, and EBT card reloads, all while most USDA staff are furloughed. Right? States transmit beneficiary files to EBT vendors by mid-month for on-time loading. Disrupting that for custom proration could delay payments into December, which would be spiking fraud risk and admin costs. A few states, Connecticut, Vermont, are scrambling with their own rainy day funds for short bridges, but that's patchwork at best. Massachusetts alone needs $240 million monthly and isn't ponying up yet. Food banks are bracing for a 20 to 30% demand surge, but they're already stretched thin. As of this afternoon's hearing, Judge Talwani sounded inclined to side with the states on forcing some fund release, likely partial because she knows she can't demand the whole thing when there ain't no appropriation for it because she go to jail. Calling the admin's stance not persuasive on congressional intent to protect entitlements during shutdowns. She plans a ruling soon. She said possibly by end of today, but that didn't happen, which could mandate prorated payments despite the headaches. If that happens, expect appeals, of course, and SCOTUS will shoot it down, and it's not coming. The November payment via that disaster SNAP fund is not going to be used even for a half payment. It's not going to happen. So, Grok asked me what's my read on how Talwani lands this, and I said the proper ruling from her would be to order Democrats to give a clean CR, or at least work towards that, period. Anything else will see grounds for impeachment or the very least judicial complaint. I said the warning was very clear in the government's brief. Talking about demanding they violate the specific law they mentioned is criminal statute. Did you catch that? And on top of that was smacked down to a district lefty judge today for trying to be a dictator and micromanaging out her land from none other than 7th Circuit. Did y'all know that that judge who had the Border Patrol chief being hauled into the court micromanaging for show? And then he goes out on the media and says, yeah, I'm fine with this because we're going to put on the record every single day that there's anything peaceful going on out here. We'll have to use tear gas because they're so violent, while the 7th Circuit's trying to say that it's not violent. So yeah, bring it on. And they immediately reversed her. The 7th Circuit reversed her order to make him come in and bring the videos with him to show and put those videos on record, because the 7th Circuit doesn't want it on record because they know that will show how bad the 7th Circuit trying to claim that there's nothing violent going on out there is going to look. And they know SCOTUS is fixing to slap down 7th Circuit, okay, for trying to act like all that stuff over there was peaceful and then try to take the power of the president on his position on when to use the militia. Okay, these district judges are out of control, right? So the 7th Circuit knew. The 7th Circuit's got so much blowback. So the 7th Circuit overruled that judge and said, look, you can't micromanage them like that, right? Anyways, slap down from the 7th Circuit. That's what I'm talking about right here when I say that. So this judge, knowing this is not the fix, the Democrats will be right here again next month unless they're told to give a clean CR. On top of that, the judge knows there will be an immediate appeal to SCOTUS, and no way will SCOTUS give power to a measly district judge to dictate how the government borrows from various funds, all locked in by statutes, which would be a crime, right? It says, I get where you're coming from. This shutdown's turning into high-stakes game of chicken, and the SNAP feels feels like an exhibit A for why Congress needs to quit posturing and pass a clean CR before the next fiscal cliff hits. Forcing judges into these calls isn't just inefficient, it's a blatant punt on lawmakers' jobs. You're right that anything short of that resolution kicks the can, leaving states and families in the lurch again on December or whatever the next impasse lands. And yeah, I caught that line in the government's opposition. When I saw that, oh, I knew they was warning this judge. And I remember back to February and March when literally all the Republicans were being so ornery. They were supporting the whole Elon let's impeach the federal judges nonsense, which I kicked back on that. I'm like, look, you can't talk about impeaching judges because you don't like their rulings. Now, if they do something that's actually bordering on criminal, that's when you impeach them. Okay, so stop trying to manipulate, intimidate the judges. I was very much against the Republicans for doing that, right? But this is definitely walking the line of criminal behavior of a judge. It's definitely criminal behavior of Democrats to not only lie to the public, but to demand that they borrow money from other funds that it's not appropriated for. That's a felony. It's literally smack down a felony, and they know this, but they're just doing it for show to defend themselves to their voters because they know that what they're doing is wrong. Anyways, but they mean it. They ain't playing. They're not just trying to like strong arm this judge. They mean it. They're giving them the warning to this judge. If you tell us to release $9 billion and borrow from other funds that's violating the law to do so, you will be facing the law on the other side of the bench. And I know that judge read between the lines in that brief. So the criminal statute warning in the brief. Spot on. The Department of Justice filing, docket entry 6, does not mince words on this. They explicitly call out the plaintiff's push for full November disbursements as a blatant violation of the Anti-Deficiency Act, which is, by the way, a criminal statute that forbids the United States from making such an obligation without an appropriation. So no, contrary to the lying Democrats, you cannot just go borrow from other funds. And pointing at what's going on in Argentina, which is coming from a fund that they have appropriations from including the Democrats. They know they just playing games. They know that the average person doesn't know that. They know that they can point the fingers at the Republicans for doing stuff with Argentina and spending money over there, and that they would believe that they have money. They're just dumb. I'm not trying to be mean, but they're just dumb. Like, they just don't know how it works, I guess. It's like, I want everybody in the whole wide world to know, okay, in America, every single thing we spend money on in our government, it's got an appropriation to it that's voted on by both Congress and of Republicans and Democrats, and it is locked in by statute that they can't just borrow from that fund and put it on something else. I want everybody in the whole world to know that, please. Thank you. That's straight from the 31 U.S.C. 1341, which makes it a felony up to 2 years in prison and fines for federal officers to spend or obligate funds from what's being appropriated. So I do believe at this point our Republicans should be chastised for being lackadaisical because they have not pointed at the Democrats of conspiracy to commit a crime by demanding that money be taken from other places, which is a felony. And I demand that they call them out as standing on the floor of our congressional, using their platform on public taxpayer dollars hour by conspiring to commit a felony by demanding the Republicans use money from other funds. They need to call their behavior criminal, and if they don't, shame on them. They need to go to SCOTUS and demand a declarative injunction to order that Congress, the Democrats, cannot demand that the Republicans spend money for political gamemanship and conspire to commit a crime to take money from other funds. They need to take that to SCOTUS and get a declarative injunction. And that will be record for the whole world to see that the Democrats, not only did they commit attempted genocide on 42 million people in our country for leverage, they committed a crime with their positions by demanding that we take money from other funds. That's what they did. And I demand that the Republicans do exactly just that. And if they don't, they're being lackadaisical. Congress power of the purse in action. The brief hammers that contingency reserves are not a blank check. They're statutorily defined emergency like disasters, not shutdowns. Okay? So technically, now she might not be impeachable because she can just interpret that disasters could be, shutdowns could be emergencies. That's that could be an interpretation, but technically it does border criminal that she's trying to use the DSNAP 5.25 billion for something it's not appropriated for. The DSNAP fund is not for regular payments. It's specifically for disasters. But it's a gray area where technically she's just using an interpretation, and judges have a lot of discretion on interpretation. Even if it's horrible and blatantly stupid, they still have a little bit of protection there. Okay. Even partial releases risk crossing that line if they exceed the 5.6 billion pot, is 5.25, without explicit authority. It's a stark warning. They gave her a stark warning. Comply with a broad order, and USDA brass could face indictments. So it's not going to be the USDA that will face indictments. It will be the judge that will face indictments, because she's ordering a conspiracy of crime. She's committing a crime by ordering the USDA to commit a crime. Okay, so she could not use her bench for that, and she knows this. Talwani grilled the Department of Justice lawyers on this today during the hearing, asking if a prorated approach, such as half of the allotment, dodges the ADA trap. They conceded it might, but only if narrowly tailored, which adds fuel to your point about judges overreaching in admin details. Now, the Seventh Circuit smackdown nailed it. That was a fresh, appealing gut punch to the judicial overreach, and it's rippling through these shutdown cases. Yesterday, October 29th, a Seventh Circuit panel slapped an administrative stay on U.S. District Judge Sarah Ellis's order in a Chicago immigration and enforcement suit. Ellis, an Obama appointee, had mandated daily in-person briefings from Border Patrol's Chicago Sector Chief Greg Bovino, because they've been using tear gas. And they're like, well, can you please come in and show me the videos of what's happening and why you're using tear gas so I can see? I'm just like, are you kidding me? If you think that we've used force wrongfully, then sue us, because this is our job, lady. That's basically what the Seventh Circuit said. Enforcement ops amid the shutdown. So the Department of Justice called it a micromanaging the day-to-day operations of an executive branch law enforcement agency, and the appeals court agreed, pausing it pending full review. The one-page order cited separation of powers, echoing broader Trump admin arguments that district judges can't dictate executive ops without clear statutory hooks, especially in a shutdown where furloughs are already hamstring agencies. It's not directly SNAP related, but the timing is perfect. It signals higher courts, and likely SCOTUS on the cert, will not tolerate dictator vibes from the bench on funding or enforcement tweaks. And certainly not political showmanship playing to the media, because we're running right close in to mid-election year, right? She knows what she's doing. Talwani, sharp as she is, would have seen the headlines, expect her ruling to thread that needle carefully to avoid a quick reversal. But she knows it's going to be reversed. She knows. Talwani's likely landing and SCOTUS path. From the hearing transcripts and post-game reporting, she's telegraphing a partial win for the states, ordering USDA to tap some contingency funds for prorated November benefits. And basically that would take the entire DSNAP disaster fund in a hurricane season, because hurricane season goes till the end of November. So pray tell, if we have a disaster, nobody gonna get no SNAP, because she didn't order the DSNAP to be used, right? Framing the shutdown as an emergency, trying to rewrite that law of what an emergency is, okay, instead of telling them to just pass a clean CR like they did in 2019 to avoid this crisis that they have manufactured, okay, totally being biased, which she's facing a judicial complaint because of that. If you don't have money, you tighten your belt. You're not going to make everyone drop dead. This right here, this is where she's going to have a record for judicial inappropriety. This one right there, she now has a record. She will have official complaint. Probably people, she made so many people mad with this, she's probably already got thousands of complaints already sent to the circuit. Like, you're a federal judge. You don't get to make these kind of comments for political show. You don't get to blame them, especially when the Republicans have filed 13 times to open the government, and they have begged and begged and begged for a clean CR so they can get people paid. No, you don't get to make comments like this. No, you don't. Because this one just cost her, right? She put a turd on her bench today is what she did. And dismissed the admin's non-emergency line is unpersuasive. But that's okay, because she knows it's going to be Uh, she knows it'll be reversed. So the ruling was expected and did not come. He says, you're dead right on the appeal. The Department of Justice is primed to file an emergency stay motion to the First Circuit by tomorrow, then straight to SCOTUS shadow docket if needed. There's no way the conservative majority greenlights a district judge rewriting appropriations law. That is not going to happen. Never going to happen. That would gut the Article 1 and invite chaos in every shutdown. We've had 21 shutdowns since 1973. So precedents like Train versus City of New York 1975 reinforce the judges cannot force inappropriate spending. No, they cannot. No, they cannot. And recent cases, impoundment fights, show SCOTUS deferring to executive discretion on funds. So if Talwani goes broad, it's reversed. If narrow, just unlock the pot. Let the USDA states sort proration. It might stick short term, but still pressure Dems for a CR. But it's not going to work. They're not going to go for it. It's not going to happen. So people need to know this and be prepared and not be looking at this case like, oh, my money's coming. Because, honey, no, it's not. I wish it was. I'm not saying I don't want it to be. I'm just saying we need to face reality here. So bottom line, this is Congress's next to fix. Clean CR or not, but yeah, anything else just breeds more lawsuits, suffering, impeachment threats over judicial ruling. Well, that's nuclear, but the frustration's real when shutdowns hit entitlements. This is hard. If she drops the order soon, want me to pull out and dissect on thoughts on Thune's holding the line in the Senate. And I said that okay, so I said, well, she's going to face judicial review. So, of course, it gives me a template for filing the complaint, and I will be filing the complaint. That is going to happen just for the comment she made alone. And this is not, she hasn't even issued a ruling yet. Okay, you don't get to use your bench for political activism. That's unacceptable behavior. I expect fully from Democrat and Republican judges both. I expect full non-biased behavior when you're in the process of your cases and in your rulings. I will not tolerate any kind of political showmanship from any judge, from any bench. You will not abuse our judicial department in that manner. Okay? And I defended the judges when the Republicans were attacking them earlier in the year just because they didn't like the rulings. And they hadn't really done anything wrong other than to rule, based on what they were going by the law, okay? And they were just out there intimidate the crap out of the judges. And I stood up for the judges. I'm like, it's not okay, right? But on the same note, the judges cannot play political activism on their bench. No, not acceptable. And if a Republican judge does it, I'm going to be the same way. Don't play games with the bench. I said, you've raised a serious charge. He says, you're not alone in seeing Talwani's not going to make everyone drop dead because it's a political game. Comment is a partisan shot, especially when she directed it at the administration's legal stance. So that line delivered from the bench during the October 30 hearing has already sparked backlash all over the internet, basically. And in conservative circles is evidence of prejudgment. So yeah, a whole lot of people file a complaint on her just for that one comment alone. No, girlfriend, don't be playing to the media. It's one thing to push for statutory interpretation that protects beneficiaries. It's another thing to frame the dispute as Republicans playing politics with food, which risks violating Canon 3 of the Code of Conduct for the United States Judge. A judge should perform the duties of the office fairly, impartially, and diligently. And from here on out, I, Missy, starting on October 30th, 2025, have become the Judge Talwani watchdog. Every time she has a case, especially if it's politically toned, I will be watching everything she says. And anytime she behaves in that manner, I'm going to be on it. No, you don't get to play like that. It says you're correct on the core constitutional point. Article 1, Section 9, Clause 7 vests Congress, not the judiciary, with the power of the purse. No district judge can compel the executive to spend unappropriated funds. Full stop. The Supreme Court has been crystal clear on this since Reeside versus Walker, 1850, and Train versus City, New York, 1975. Courts cannot order spending without statutory authority. So even if Talwani rules narrowly, say interpreting 7 U.S.C. 2026 to allow contingency and a shutdown, that's still legislative rewriting. It's not judicial enforcement. And if she mandates proration or a full disbursement, it's dead on arrival at SCOTUS. So on judicial review and accountability, you're pushing for congressional review or judicial discipline. So here's what's actually possible. The Judicial Council complaint, 28 U.S.C. Section 351, any person can file it. Threshold, conduct prejudicial to the effective and expeditious administration of the business of the courts. Her comment is on the record. A complaint could be filed with the First Circuit Judicial Council But it's usually a private reprimand or dismissal. Okay. Um, then you have this reverse on appeal. It's near certain. If she orders spending beyond contingency statute, the Department of Justice already signaled emergency stay. So the Seventh Circuit stay you mentioned earlier is a live warning shot. Appellate courts are done with district judges micromanaging executive functions during shutdowns. So if Talwani goes beyond unlocking the $5 billion contingency pot exactly as Congress wrote it, no probation mandate, no operational directives, the reversal is swift. What she should do, your view, legally grounded, you want her to dismiss the TR motion for lack of jurisdiction, declare the SNAP funding lapses absent a CR, urge Congress to pass a clean continuing resolution. That's not just politically clean, it's constitutionally mandatory. She has no equitable power to fix the lapse in appropriations. The plaintiff's real remedy is political, not judicial. So prediction what she'll actually do based on her hearing and her prior ruling, she's pragmatic, but she leans towards statutory purpose over strict textualism. And we know now that she's extremely showmanship when it comes to media. She's extremely biased. She's a pandering judge to her Democratic buddies, okay, the way she acted today. So she'll order the USDA to disperse full contingency reserve, which is the $5.25 billion that is for disasters, on a prorated basis, which will take the states weeks to even do. Frame the shutdown as triggering the emergency. And she'll do this because she knows that it will hurt. She thinks that they'll be able to use this to hurt Trump, even if it's smacked down on reversal, because somebody said they'll use it in their arguments when it comes to election. You see, this judge over here said that he was wrong for this. He sat on money, and all these people will believe it. And then they'll say, and then the mean, evil, conservative-leaning SCOTUS, kicked it back. And I'm like, do you know how many judges that are even Democratic that have reversed stuff that have been attacking Trump? So, but anything that they can use on their political platform, it's all politics, bottom line. So frame the shutdown as triggering the emergency clause in 2026, section 2026. Then she will stay her own order with 48 hours to appeal. This gives Department of Justice time to file an emergency stay within the First Circuit, which is stupid because literally this is October 30th and the first is two days from now, and people should have already, they should have their money tomorrow, like literally, and it's going to take weeks for the states to prorate people. Do you know how dumb that is? All right. So it says, you're right. Anything but dismissal invites reversal. Her comment was intemperate and risk of misconduct complaint. Oh, yeah. It's not a risk. It's happening. Okay. It's a done deal. She is going to get a misconduct complaint by many people in the United States of America. That whole First Circuit's going to be flooded with a bunch of complaints on her. Yeah, that's fixing to happen. But impeachment, probably not unless, and here's where I say, this is what I say to Grok on this one. Let me go back. Okay, I said, I digress, that if she orders them to do something that is tantamount to criminal, as we discussed, that is impeachable. Okay? That's a slam dunk case. It's impeachable. And it says you're not wrong to draw the line there, and you're sharpening the focus on the only scenario where impeachment does become viable. If Judge Talwani explicitly orders federal officials to violate a criminal statute like the Anti-Deficiency Act, 31 U.S.C. 1341, knowing it carries felony penalties and without colorable legal basis, okay, then yes, she absolutely could be impeached. Yep. And they have warned her. And don't think for a second these Republicans they're not just saying that. They mean it. If you dare try to order us to take funds in violation of the law, girl, say goodbye to that robe you're wearing. I mean, they didn't say it like that, but when they say what they said today, she better read between the lines very carefully. So the Department of Justice warning was very explicit. In docket entry 6, the government wrote, plaintiffs' request for relief will require defendants to violate the Anti-Deficiency Act, a criminal statute. Any obligation or expenditure in excess appropriation is punishable by fine and imprisonment. Okay, so they told her in the hearing today, especially after she got a little juicy with them, they warned her again, in her face, on the record, do this and you're ordering a crime. Oh yeah, they said that to her, to her face. from the hearing in her signal, she will not order a 9.2 billion payout, which is how much is needed for a full November payment. That's why we have to tell these Democrats to knock it off. If you want Obalal reversed, then you need to take it to SCOTUS. End of story. Open the government. She will likely order release of the full disaster fund, okay, which will be shot back down. No, people aren't even going to get. I would say probably the possibility of them succeeding in wiping out an entire disaster fund and letting that stick is probably 20%. So you have a 20% chance to get a half payment for November from the disaster fund. Okay? And I would say that would be a curse because you're stealing money from people that could suffer a disaster. Right? She acknowledged the ADA risk and said, I'm not telling you to violate the law. And I think that people who want these Republicans to take this disaster fund and refuse to tell the Democrats to open up the government and quit playing games, I just think they're guilty. They're just guilty people walking around with guiltiness all over them. Like, they should be telling their Democrats, stop playing games. Look, I'm willing to stand up against Republicans because both parties do stuff wrong. And that's reality. And if I see the Republicans doing something wrong, I'm calling on it. And all I'm asking is people, if you're a Democrat, tell the Democrats how wrong they are. You don't play games with people's food. They could have issued a clean CR already, at the very least, right? But they won't. And they did in every other shutdown. This is the only time that I know of that they haven't issued a clean CR. And that's just treason, in my mind. The impeachable line, what would cross it? Knowingly command a felony. That's impeachable. Usurp the Congress purse. That's impeachable. Defy SCOTUS precedent. Train versus City of New York. Trigger immediate Department of Justice refusal on emergency appeal. That's judicial tyranny. And yes, it's impeachable. So the historical precedent, and I went over this before, Judge Alcee Hastings in 1989 was impeached. Actually, there was more. I don't know why Grok isn't able to pull up. There have been more impeachments than this. I'll have to go somewhere else to get that history. I do have some articles from from some Ivy League legal blogs about previous impeachments. I'll bring those out in a later date. But yes, judges can be impeached. They can be prosecuted too. But if Talwani orders a crime, that's uncharted. And you know House Republicans would 100% move on that. They're just looking at her like, a double dog dare you. They're just like, I'm sure, they're just like, yeah, go ahead, Judge. Go ahead, I dare you. She knows. She ain't gonna order that. So anyways, we shall see, guys. We shall see. Let's see who's in the chat right now. Hey, what's up? Gaming. One second. Whoop. Well, uh-oh. Hang on. Looking for my comments here. What'd I do? Like, double, done, hearts. Thank you. I'm going to add you as a mod. And who else is in here? The native Ike. Oh, hey, what's up? Let me put... Did I add you as... Okay. Alright, so then we got Angels in here. Ubi Girls in here. Okay. Alright, so the next move, the Domino's post-order chaos, Department of Justice emergency stay, SCOTUS shadow docket, cert petition stay by November 1st. So this is basically the Grok. So this is basically, I'm going to show you this order that Grok predicted that Judge Indira Talwani will make. And next moves. Well, I'm not, you know what? I'm going to pray that the judge will not do what Grok is predicting. I'm going to pray that the judge does the right thing and uses her bench in the appropriate way, because she's already poo-pooed on her bench today. Doing what she did was very, very bad. I'm going to pray that she's going to repent and turn into a better light of the judicial bench and order that they're going to dismiss the TRO and say, look, I don't have the power to dictate what can be done with funds. And even if they issue a temporary, a half whatever, it's going to take weeks for it to come through. I can't even predict ordering 50 some states to go and prorate for 42 million people, how long that would take. This isn't the answer. The answer is for the Democrats to issue a clean CR. And by their not doing that, they are the ones that are playing with people's lives. And in the name of Jesus, I ask other people to pray that she will do just that. Okay? And on that note, I'm going to end this. Thank you all for stopping by. I will be stopping by your channel.